by the last week. So I assume that everybody is adept by now with these virtual hearings, and that if there are more than one people in the room, if any of the laptops that are logged on are not on mute, we'll get welcome feedback. So if there are one of the laptops on mute or turn off any additional laptops, because laptop voice and until that is resolved, we're not going to go next.
Judge, there does appear to be a disturbance somewhere. I can't hear it all.
Yes, so I was going to ask Mr. Mbikwa to mute and turn off his camera so that we can possibly locate where the noise is coming from.
Judge, sorry, I was muted. I was simply putting on my camera to say I think it's coming from Mr. Epstein's computer. That's what's lighting up, is that the computer logged in as Andy Best isn't on mute. There, now it is.
All right. All right. See you there.
Ladies, that better now.
It seems it's coming through from your side.
It's not better, but it's definitely coming through from your side, Hilton.
Just making sure that every device is off here, except the one I'm on. I'm on an investor's device because, notwithstanding our best intentions, this morning. Is that clear now?
We still get some background on and off. It's off now.
From our side, we're not getting any feedback. It's clear from our side. We can hear everybody clearly.
We are the ones who are getting feedback from your side.
Yes.
It's Mr. Best's computer. You need to get your computer, Mr. Epstein.
No, I'm sharing the computer with Advocate Bester because we had a problem this morning linking to our big screen, so we're only using one device.
I see.
Can we go out for a moment and come back in again?
Right, we'll adjourn for a few minutes to allow you to get in and out.
Thank you.
Right, are we now all in?
Judge, we are, I suspect, Mr.
Yes.
I suspect they are. Yeah.
Is that better, milady?
Much better, thank you,
Okay.
Mr.
Gone back to the old-fashioned way, just having one device and no big screen.
I'm sure the big screen will come in due course. All right, Sibylle, will you call the matter, please?
Civil file matter appearing before Judge Suwendo. The case number is 42728 of 2010. The parties are leaving hands. The unit trust managers.
Yes, thank you. You may mute appearances, please.
Thank you. Milady, I appear for the plaintiffs in the matter, together with Advocate Andy Bester, SC, and Advocate Anele Ngidi.
Yes, thank you. Mr. Bum?
Thank you, my lady. My lady, I appear for the defendant in the matter, together with my learned friends, Mr. Edward Fagan, SC, and Mr. Michael Mbikiwe. My lady, we are instructed by Weber Wenzel attorneys. My instructing attorney is Mr. Fuller Bender.
Can you give me the name of your second counsel, please?
Mr. Michael Mbikiwe, Mbikiwe.
I've got him, but the other one?
Mr. Edward, EDUARD, Fagan, FAGAN, SC.
Is there a reason why this is a complete male panel? I mean, male representation? Where are the females? Yeah.
Well, if you're addressing our team, milady, then Anele Ngidi is here with me.
Oh, I want to see her.
Yes.
Very well, Miss Ngidi.
Pleasure to meet you.
We are an all-male team. I can't give you a reason for that, but it is, of course, regrettable.
Yes.
Can I say this, my lady? The team was composed quite differently earlier in the matter. This is at a time when there was an exception taken in the matter. As a result of questions of availability and the like, there was a change, and that's how the cards fell at the end, maybe. So it was an evolving team, which resulted in what we did.
We raised that because there is an expectation that the lead would be aware and take such steps as unnecessary.
You're absolutely correct to do so, my lady.
Yes, thank you. Mr. Epstein?
Lady, just one or two housekeeping matters. The two of the third parties, that is Mr. Milan and Mr. de Jong, have withdrawn their defences, and their notices of withdrawal were filed last week, and they've been uploaded. So that is the first matter. The second matter is, milady, we understand that you have approved the protocol, and the process I wish to follow with your leave is there'll be an opening address, and after that we intend to call our first witness, who is Mr. Stamela. And we think that will take most of the day. If we should finish Mr. Stamela's evidence earlier, then we would ask to stand down, because our next witness is going to be Mr. Papadakis. He is in Cyprus, and we have made arrangements for him in terms of the protocol to attend at an attorney's office in Cyprus, and that arrangement is only from tomorrow morning. So if we do finish, then we would ask your leave to stand down. Lady, the opening address we have uploaded now on case lines. It's 018-1.
Thank you.
Thank you. So if I may proceed then, milady, if you have it with you. we've tried to set out what the case is in a nutshell.
My lady, may I ask if I could just be given a couple of minutes because I've got to put it onto a different device just to get that on.
And what we'll do then, my lady, now is we'll email it to Weber Wenzel as well.
If that could be done, it would make it immensely easier. Thank you.
We'll do that right now.
Thank you.
And also, between both counsel, can I recommend, because I'm keeping an eye on the screen, that if you do want to address me on any issue during the address of the other, just raise your hand, use that the device, so that I can recognize you. Yes. Mr. Epstein.
Is Mr. Baum ready for me to proceed? He was looking.
I am ready, thank you.
Okay, thank you. So, my lady, it's a delictual action in which the plaintiffs, in their capacities as trustees of the Living Hands Umbrella Trust, are suing the defendant, which is Old Mutual Unit Trust Managers Limited, for damages suffered in excess of 850 million rand, together with interest. At the moment, the total claim with accumulated interest exceeds 1.7 billion rand. Milady, there were a number of changes of names of the trust and of the administration company, and it gets confusing, and I'm going to endeavor to simplify it, and we tried to explain it, milady, with an organogram which is attached to right at the end of this opening address at 01826. But I'll get to it, milady. In the meantime, just to try and encapsulate the matter, on the 19th of October 2004, the trust, which is the Living Hands Umbrella Trust, as it's now called, the trust held substantial funds in excess of 1.1 billion rand, and that was held for the benefit of tens of thousands of dependents of deceased members of pension and provident funds. Milady will hear that most of, about 80% was held on behalf of the Mine Workers Provident Fund members. Now, on this day, that's 19 October 2004, control of the trust's then sole trustee, and administrator, known as Mantadia Asset Trust Company, MATCO. Milady will hear the name MATCO repeated regularly in this matter. On the 19th of October, control of MATCO was handed over to a handful of individuals under the leadership of one J. Arthur Brown, under the Fidentia label. And the funds at that time were invested, at the time they were handed over, or just before they were handed over, they were invested through Old Mutual in investment schemes. But over a period of about 2 to 3 weeks, from 26 October 2004, all the funds were redeemed to MATCO, which was now under the control of Fidentia, and then most of these funds, we say over the period 26 October to March 27, 2007, that's 3 years, most of these funds had been unlawfully and fraudulently and recklessly dissipated by Fidentia, which resulted in a loss of almost R1 billion by the trust. Now, by virtue of the nature of the trust, the provisions of the trust deed, the application of legislation, there's a service level agreement which you'll hear about. It is the plaintiff's case that Old Mutual owed the trust and the trust beneficiaries a legal duty to comply with certain statutory duties and duties imposed on Old Mutual to protect the rights of the beneficiaries, many of whom were women and children, and constitutionally, in terms of sections 27 and 28, they had a duty to make sure that those funds were protected because they were for the benefit of children. And our case is that Old Mutual breached those legal duties and thereby caused the loss. Milady, can I take you immediately to the organogram right at the end? Because without that, it sounds confusing, but truly it isn't. One has the what is now known as the Living Hands Umbrella Trust. And there's an administration company now known as Living Hands Pty Limited. And you'll see, milady, on the left side is the administrator. it was originally called Mantadia Projects 2 Pty Limited. Then on 27 February 2002, it changed its name to Mantadia Asset Trust Company, which is known as MATCO. And then in June 2005, once the Fidentia people got hold of the company, they changed the name to Living Hands Pty Limited. But most of what you will hear happened when it was called MATCO. And that's why when we say MATCO, we mean the first plaintiff, we mean Living Hands Pty Limited, but it was at that stage called MATCO. And then the trust on the right-hand side, it was originally known as the CFM Trust. It changed its name to MATCO Trust. And then on the 3rd of May 2005, again, under the control of Fidentia, it changed its name to Living Hands Umbrella Trust. But whenever we refer to MATCO throughout, Milady, we are referring to the administration company and the trust. And then at the bottom, we've shown that these are the plaintiffs. They are the trustees of the Living Hands Umbrella Trust, and we've set out when they were appointed. So, Milady, if I can go to the relationship on page 3 of page 26. The plaintiffs are the trustees of the trust, and the trust came into being as follows. The trust was created in terms of the deed of trust, and it's in the pleadings, it's attached, but Milady, we've set out the pertinent clause here, which is this. This is why the trust was created. In order to avoid a proliferation of trusts, which would arise if a separate trust were created to administer the funds of each beneficiary, the settler is establishing in this trust, but on the basis that the amount to be administered or held on behalf of each beneficiary shall constitute a separate trust fund, being the beneficiary's trust fund. The trust fund of each beneficiary shall be maintained in a separate fund in the books and records of the trust. So what that means, my ladies, there's one trust, but there are thousands and thousands of dependents, and they don't each have their own trust, but in the books of the trust, they are kept separately, dealt with separately. And then we've said that the trust underwent name changes. I've just taken my lady through that, through the organogram. Then we come to the administrator. The plaintiffs are the trustees of the trust. The first plaintiff is Living Hands Pty Limited. It's the administrator of the trust. This company was the sole trustee of the trust until the appointment of the second and third plaintiffs. It was a corporate trustee, my lady, and as a corporate trustee, it has to have one person who is registered with the master as the nominated person for the corporate trustee. So it was the sole trustee until the second and third plaintiffs were appointed as the trustees together with Living Hands. And then we've said the company underwent various name changes, and I've already dealt with that through the organogram. And in 10.2, again, I'm trying to avoid confusion, but the second plaintiff, Vilna Liva Prela, and the third plaintiff, Mr. Stamela, Advocate Stamela, were appointed as trustees of the trust. And when they were appointed, the trust was then called Living Hands Umbrella Trust. The name of the Matco Trust had been changed by the Fidentia people when they took control. And they, as I say, they also changed the name to Matco. So, my lady, now we come to the defendant, OMIT, Old Mutual Unit Trust Managers. And right throughout, you see that they are called OMIT. They're a management company, and they're registered in terms of the Collective Investment Schemes Control Act. Originally, my lady, we sued 19 defendants. They were cited, but now we're only proceeding against Old Mutual. The others have withdrawn the claims or have not defended. And then OMIT joined 6 parties as third parties. And as I've said, Mr. Milan and Mr. de Jong have withdrawn their defenses, and the others never defended. So it is the plaintiff's case, my lady, that OMIT was a financial institution as defined in the Protection of Funds Act. It's called the Financial Institutions Protection of Funds Act. We refer to it throughout as the Protection of Funds Act. And then they were registered as a manager, importantly, as defined in Section 1 of the Collective Investment Schemes Control Act. And they were obliged to exercise the care, diligence, and skill required of a trustee, as required by the Trust Property Control Act. Now, at all relevant times, the trust received money from beneficiary funders. Now, who are those beneficiary funders? They're pension funds, duly registered. It's disputed, I must tell my lady, that these funds were duly registered, but I'll come to that in due course. So they received funds from pension funds, and such as the Mine Workers Provident Fund, which money was paid to the trust and is paid for the benefit of the trust beneficiaries. Matco was the sole trustee of the trust. That is now Living Hands P2 Limited. They were the sole trustee of the trust. And they're the trust administration company. You can't do that anymore, but they were the trustee and they were the administrator. And they were obliged to manage the funds for the benefit of dependents and nominees of deceased members of beneficiary funders, including the children for whose benefit the money was in trust. We refer to the relevant statutory provisions which we say impose duties on OMIT and which we say they did not comply with. And I would just highlight now some of those duties. There is CISCA. CISCA is the Collective Investment Schemes Act, and a collective investment scheme is defined, and in terms of section 2.1 of CISCA, a manager, and I've said that OMIT was a manager must administer a collective investment scheme honestly and fairly, with skill, care and diligence in the interest of the investors and the collective investment scheme industry. And in terms of section 4.4 of CISCA, a manager must maintain an open and cooperative relationship with the office of the registrar and must promptly inform that office about anything that might reasonably be expected to be disclosed to such office. Milady will see that later, that we say they failed in that duty. They should have reported the matter, which would have protected these funds. And then in terms of the Protection of Funds Act, section 2, a director, member, partner, official, employee or agent of the financial institution who controls and administers any funds of the financial institution must, with regard to such funds, observe the utmost good faith and exercise proper care and diligence. And in terms of the Trust Property Control Act, the trustee shall, in the performance of his duties and the exercise of his powers, act with the care, diligence, and skill which can reasonably be expected of a person who manages the affairs of another. Then we refer to the Constitution, where everyone has a right to have access to social security, including if they are unable to support themselves and their dependents, appropriate social assistance. And importantly, section 28, every child has the right to be protected from maltreatment, neglect, abuse, or degradation. And in subsection 2, the child's best interests are of paramount importance in every matter concerning the child. And as we will submit, milady, that the Old Mutual, OMIT, knew that the money that they were holding was being held for women and for children and dependents of deceased members of the Provident Funds, and including the Minor Workers Provident Fund. So, my lady, at paragraph 23, we talk about the relationship between trust and OMIT. In May 2002, and again in September, a service level agreement was entered into between between Matco and the administration company and OMIT. In terms of that service level agreement, funds were invested in unit trusts administered by OMIT. As of 15 October 2004, and that date's important because it's from that date onwards that the problems arose which gave rise to this claim. And by the 19th of October, 4 days later, the Fidentia crowd had taken control of this, of Matco, and a few days later of the money. So as at 15 October, 1.1 billion rand was invested for the trust by OMIT in various portfolios forming part of the collective investment scheme as defined in CISCA. So what happened, my lady, is the trust gave its money to OMIT to look after, and they then invested it in various portfolios. Then, so far as it is not admitted, we will prove that OMIT knew that the funds invested by OMIT for the trust constituted funds for the benefit of dependents and nominees of deceased members of beneficiary funders, for whose benefit the money was paid to the trust, including children. talk about Fidentia and explain who they are. They were a private company. They were previously known as Brown Brothers Holdings. And Fidentia Asset Managers, FAM, you will hear about FAM, was a wholly owned subsidiary of Fidentia Holdings. And Fidentia Holdings bought the shares in the administration company when it was known as Matco. Investec was one of the shareholders. There were other shareholders whose interests were held through trusts. Investec held theirs in their own name. And that Fidentia Holdings bought those shares in Matco. That's how they got whole control of the company. And for the period 11 October to 31 January 2007, Messrs. Brown, Milan and Mulder, amongst others, were nominees of Matco in terms of Section 6 of the Trust Property Control Act. I mentioned, milady, that there was only a sole trustee, and the sole trustee then was Matco, and they had to have a nominee. And these Brown, Milan and Mulder over the time were nominees of Matco. Then came the curatorship. On 1 February 2007, in terms of an order of the Cape High Court, the whole of the business of Fidentia Holdings, FAM, and a company called Bramber Alternative Pty Limited, which was also owned by Fidentia Holdings, were placed provisionally under curatorship. And the reason they're placed under curatorship is because there was a report which was conducted in terms of Section 3 of the Inspection of Financial Institutions Act. Now, there's a summary of the findings of the report the report is at 01512 in case lines, but we've set out here just some of the findings of that report, which led to the curatorship. The lady will see at 331.2.1 that FAM had not, this was from the report, FAM had not fulfilled any of the duties imposed on it with regard to the maintenance of proper accounting records and auditing requirements. So we're talking about the period from 2004, Fidentia Holdings takes control of Matco. They changed the name to Living Hands. And then for a period of 3 years, they failed to lodge audited financial statements. 31.2.3, analysis of client funds received, withdrawn and invested indicates that 689 million of client funds were unaccounted. The inspectors said, and we quote, "We believe that these funds were utilized for disbursements, misappropriations by the Fidentia Group / Brown, and the purchase of other assets that were not disclosed as part of the client portfolio." Milady will hear when Mr. Papadakis gives evidence of how this money was squandered and what it was squandered on. The inspectors were convinced that FAM would shortly be unable to honour its monthly obligations towards clients without liquidating existing client private equity or property investments. Funds received from clients intended for investment were utilised to defray business expenses and to acquire property and private equity investments for the Fidentia Group. FAM had not, with regard to those funds, observed the utmost good faith and had not exercised proper care and diligence. FAM had not complied with requirements pertaining to mandates with clients. FAM had not disclosed all the funds under management. They misappropriated funds belonging to TETA. That at 31.2.9. There's an extra camera on, I see. Whose camera is that? I don't know if it's interfering, but I see there's an extra camera on, but I'll carry on.
Just a moment, Mr. Epstein. We ask that any other camera other than the camera of counsel addressing the court, please turn it off unless you're addressing the court. Thank you. Thank you. Thank you.
Then the inspectors found that clients' assets and money were not readily discernible from the assets of FAM. At 31.2.11, various transfers had been made to offshore bank accounts held in the name of entities related to Fidentia. FAM and its key individuals had not acted honestly, fairly, with due skill, care and diligence, and property investments were artificially sold for 800 million rand. And then the report made recommendations. They said there appears to be poor corporate governance and evidence to question the integrity of management. Substantial money had been placed under the care of FAM. The investing of money might be considered to be reckless and irresponsible. The fact that client money may have been misappropriated led the inspectors to recommend that a curator be urgently appointed to ascertain the true position and maximize the value of the numerous illiquid investments of the client. And the curator should also investigate whether criminal charges should be brought against any management and or employees past or present in the group. As Milady might know, there were criminal charges against some people who were then sent to prison. On the 22nd of March 2007, so this is now 3 years after Fidentia took over, the provisional curatorship order was made final, and Dinesh Giwal and George Papadakis were appointed as curators. On 26 June 2014, Giwala's appointment was terminated and John Levine was appointed with Papadakis. The curators exercised their mandate, and on completion, their appointment was cancelled on 21 May 2020. So, Milady, what then led to the events giving rise to the claim? I've said that in 2004, Fidentia negotiated with shareholders of Matco to purchase their entire shareholding. There's a shareholders agreement, and they purchased the shares for 93 million rand. And Milady will hear the haste with which that sale agreement was concluded, despite the fact that the agreement said that the shares should not be transferred and the director should not resign until payment of the purchase price had been made. They in fact did so. And once they had done so, Milady will hear that the Fidentia people had control of Matco. They had control of monies which were some of the money was sitting with Investec. They withdrew money from Investec, which was the dependents' money, the beneficiaries' money, and used that money to pay for these shares. And they then took control of Matco. And having taken control, they went along to Old Mutual and obtained the money that was sitting there, over R1 billion, from Old Mutual. Now, what I'd like to do, Milady, is we set it out in the opening address from paragraph 36 onwards, I'd like to take you, if I can, to the pleadings, because every picture tells a story, and I'd like to show you the correspondence which was written, and just to show you how what happened over this period. So I would ask you in case lines to go to 001 189.
Yes, I'm there.
Right. So I've mentioned that the crucial period is from this time, 15 October 2004. Fidentia Holdings started to negotiate with the shareholders of Matco at round about the beginning of 2004. In fact, the shareholders agreement was signed. Give that in a moment. The shareholders agreement, you needn't go there, my lady, but it's at 0019. No, that's not it. I'm sorry. It's at 001152, and that agreement was signed, I think, on the 4th of October. On the 5th of October, 2004. So the Fidentia buy the shares on 5th October. There's supposed to be a due diligence. They've got more than 30 days to do a due diligence. Brown and his cohorts are happy without doing a proper due diligence. And then on the 15th of October, that's at 001189, 3 people, representatives of Fidentia, go along to Old Mutual, and they meet with Mr. Cronje of Old Mutual. He was the compliance officer, Old Mutual Fund Administration Services, Mr. Cronje. And they meet with Mr. Cronje, and they ask him for 150 million rand. And he's surprised at this. He doesn't know who they are, doesn't know where they come from. And so he writes a letter that day, which is at page 189. He writes a letter to Jeff, dear Jeff. Jeff is Jeff Gover. He's now deceased, and he was one of the shareholders of Matco. He was busy selling his shares to Fidentia. And he says, we refer to our telephone conversation today and confirm the following. We were approached by three gentlemen, Steve de Kock, Johannes de Jong, and Johan Linder from Fidentia Asset Management, P2R Limited, that's FAM, excuse me, who handed us a letter suggesting Fidentia's appointment as portfolio manager. Now that letter that was handed, if my lady goes to POC 10, which you will find at 001184, that is the letter which Mr. Cronje says was handed to him by these three gentlemen. And you'll see that it's a letter written on a Matco letterhead. But at this stage, at the bottom, the shareholders and directors are still Dr. Baloy, Ditz, who's now deceased, Gibbs, Gova, and it's written by Matco, that company, but it's written to FAM, Fidentia Asset Management, and it says, we hereby confirm your appointment by the company as portfolio manager with immediate effect. It's a discretionary mandate, and you're hereby authorized to instruct Symmetry investment managers to effect any decisions taken by you. Symmetry is a business unit within Old Mutual, and their advisors. So that's the letter he refers to at 001189. He says, we were handed a letter suggesting Fidentia's appointment as portfolio manager. And of course, Old Mutual was the portfolio manager. And suddenly they get this letter saying, there's a new portfolio manager. And they get it from three people they don't know. And he says, we were not fully satisfied with the validity, scope, and intended impact of the letter based on the following reasons. The manner in which the letter was signed, we feel that the instructions were vague and unclear. Coupled with this, the letter was addressed to Fidentia, an unknown third party, and not to Omit. When contacted this morning on the potential repurchase, you were not able to confirm such repurchase. We were also presented with an instruction from Fidentia instructing us to liquidate 150 million rand and transfer to their bankers. Please note that no mention is made of the specific fund from which the withdrawal should be effected. And the 150 million, if the lady will look at the previous page, it's 001188.
Just before you proceed, this letter at 184 that was handed to the Old Mutual team, it's undated. Am I correct?
That was the problem. That's what Mr. Cronje picked up. He says we were handed an undated letter. That was signed. No, I don't know if he says it, but it is undated.
I just wanted to.
Yes, but it is. We know it's that letter because he's unhappy with the way it's signed. How's it signed? It's signed by Gova, outgoing director, Matco, Brown, incoming director, Milan, representative trustee. So he's confused as to who this is. But the 150 million rand request is on is at 001188, and this is now Fidentia Asset Management FAM on the same day. Now they haven't acquired ownership yet of the shares, and you'll see the directors at the bottom were Maddock, who was in the Fidentia stable, and De Jong in the Fidentia stable. And it's written to Old Mutual Unit Trusts. We hereby instruct you to liquidate 150 million rand of Matco with immediate effect and transfer such proceeds into the following account, and they want it into their account. So here you've got Matco under the control of Gova, Ditz, and others. Old Mutual is sitting with 1.1 billion. Unknown people arrive and ask them to transfer 150 million rand to the FAM account on the pretense that they are now the portfolio manager. And of course, Mr. Cronje smells a rat. And he says, I'm not going to do this. And he writes to Gova and asks Gova, what's going on here? And then what happens is a few days later, at 001191, there's a letter, we're now at 19 October, and a letter is written by Gova. He wants to sell his shares, he wants out. And he writes it to Symmetry Multi-Manager. As I said, they're a business unit in Fidentia. 19 October, and he gives permission to Symmetry to provide information about all the investments. Well, he's selling the shares, he's selling the company, he says you can give them information. But now, Fidentia is keen to get their hands, they're desperate to get their hands on the money. So they write on the 19th of October under Matco, and they say they write to Symmetry and they write to Old Mutual Asset Management. This is an important letter. They say, "Dear sirs, kindly note that the directors of the above company," now it's Matco's the company, that's the administration company, "kindly note that the director of the above company has resolved to immediately call up the entire Matco trust and investment portfolio currently managed by yourselves. We regret that we are legally and morally unable to perpetuate the status quo for inter alia the following reasons." And then they set out 6 reasons. They say to Old Mutual, "There's no legally binding written mandate currently in existence. The provisions of the Financial Advisory and Intermediary Services Act do not appear to have been fully complied with. There is no written appointment of an asset manager. Questions around fees, performance bonuses, and incentives derived from the portfolio have not been adequately answered. There appears to be a discrepancy between the portfolio balances as calculated by Old Mutual and Symmetry." I mean, imagine that, milady, they're accusing Old Mutual that there's a discrepancy between the portfolio balances as calculated by Old Mutual and Symmetry. "Compliance documentation could not be produced and no plausible explanation given therefore. Questions around the construction of the underlying portfolio have not been adequately answered. In this regard, you originally undertook to revert with answers by 5 o'clock on 18 October. That's the previous day, which time was later extended to 6 o'clock, whereafter you confirmed to us that no mandate is currently in existence. Kindly confirm in writing by no later than 17 hours today that the funds have been transferred into the Matco bank account, the details of which you have on record." They're asking on that day for Old Mutual to pay over 1.1 billion rand to the Matco account. And on the very next day, there's a response from Chris Potgieter of Old Mutual of Omid at 001194.
Just before you proceed, can you just say a little bit more about Symmetry? I need clarity about where exactly they fit in.
Symmetry is a business unit. We mentioned it in our, yes, at 36.6.
Yes.
We just say that who Symmetry is. Symmetry multi-manager portfolios. Symmetry is a business unit within Old Mutual Assurance Company of South Africa, and they're advisors. So Old Mutual has the money, they need to invest it, and they ask their business unit, where do you think we should put it? And Symmetry tells them, gives them advice as to what to do. So Symmetry is the portfolio. They've got all the information as to where the money is invested. So Mr. Potgieter on the 20th of October writes to Matco, attention, Mr. Milan. Mr. Milan is now there's the corporate trustee, because it's only Matco as the trustee, now living hands, and he is he's the nominated person. And Mr. Potgieter says, "We acknowledge receipt of your letter dated 19 October, calling up the entire Matco investment trust portfolio. We will accept this as a valid instruction as soon as we receive confirmation of authority for the beneficial owner, the Matco Trust. We also wish to confirm that once the above confirmation is received, we will immediately liquidate all investments in the money market fund. The liquidation of all investments in the other funds depends upon the adequate notice period being received, or alternatively, we need to agree upon a reasonable repurchase schedule. I trust you find this in order." Now, on this, when one looks at this letter, what is he saying? He's saying, I've got your letter, you want the money immediately. I need to know that you're authorized to do this. And by this stage, my lady, they have purchased the shares, they've paid for them, even though they used the trust's money, but they've paid for them. And they are now, Fidentia is now in control of this company. And Mr. Potgieter says, I'll act on your instruction, just give me prove you've got authority. And also, he says, we will immediately liquidate. The liquidation of all depends on adequate notice period being given. The lady will see that there is, in the service level agreement with Old Mutual, they were entitled to be given 90 days to before they were to sell any of the units. And yet they ignored that, but that's what he means. We need adequate notice. That's what he means. And the next day, in fact, the same day, you'll see that Milan writes to Old Mutual, and he says, we confirm that the undersigned, Philippus Johannes Milan, is the sole representative trustee of the Matco Trust. We further confirm the mandates and appointment given to Fidentia as investment manager on a full discretionary mandate to act on behalf of the Matco Trust. In terms of the mandate, Fidentia Asset Management, as the appointed investment managers, mandated to liquidate the entire investment portfolio or portions thereof as they deem fit. And now they're satisfied with that, and then Old Mutual start paying out this money. And within 2.5 weeks, they pay out 1.1 billion rand to the Fidentia crowd. And we know what happened to the money after that. So, my lady, then, if I can take you forward to what our case is, at page 19, under breach of homage duties. We've referred to the statutory duties which Omid had as a financial institution, coupled with a contractual relationship arising from the service level agreements, the provision of the trust deed, and the nature of the funds. It is the plaintiff's case that Omid owed the trust and the trust beneficiaries a legal duty to comply with the mentioned statutory duties, as well as the duties imposed on Omid to protect the rights of the trust beneficiaries. It is the plaintiff's case that, having regard to the events from 15 October until the money was handed over, Omid knew or should have foreseen that a material risk existed, that the trust had come under control of individuals who may not act in the best interests of the trust beneficiaries. Milady will hear that when a few days before they've come along to try and get their hands on 150 million rand, Mr. Crony is concerned, and then despite that, we say he should have seen the risk that he was now handing money over to people who had unlawfully tried to get hold of 150 million rand. They wanted to do a test run, they said. They'll take you over the company and they need to do a test run. Not with 15 rand or 150 or 150,000, but they needed 150 million to do the test run. And it's not surprising that Mr. Crondi reacted the way he did. Accordingly, Omid should not have released the funds to Matco without having taken steps directed at safeguarding the funds in compliance with the statutory duties and the duties to protect the trust the trust beneficiaries. And we say they did not properly.
What do you mean a test run? What do you mean a test run?
No, we don't know what it means. That's what the evidence will be, that they were told that the evidence will be that they were sent to ask for the money to do a test run. We don't know what it means. We don't know what it means. The steps which the plaintiff alleges Omid should have taken, which it failed to take, are these. This is what Omid should have done. And we say, had they done this, the money would not have disappeared. They wouldn't have handed it over. Omid should have informed Standard Bank. They were the trustee of the collective investment schemes in which the funds were invested, of the facts which had taken place from 15 October. And Omid should have informed the Office of the Registrar of Collective Schemes of the same facts. And therefore, Omid failed to comply with its duties in terms of CISCA, particularly Section 4, Sub 4E, which provides that a manager, a person who's authorized in terms of CISCA to administer a collective investment scheme, I'm at 40.3, milady, must maintain an open and cooperative relationship with the Office of the Registrar and must promptly inform the office about anything that might reasonably be expected to be disclosed to such office. And moreover, we say that Omid failed to comply with its duties as a manager in terms of Section 2.1 of CISCA, which provides that a manager must administer a collective scheme honestly and fairly with skill, care and diligence and in the interest of investors. As a consequence, we say Omid contravened Section 9.1 of the Trust Property Control Act. And that says, in Section 9, a trustee shall, in the performance of his duties and the exercise of powers, act with care, diligence, and skill, which can reasonably be expected of a person who manages the affairs of another. And we say also they contravene Section 2B of the Protection of Funds Act, in terms of which a financial institution must, with regard to trust property, observe the utmost good faith and exercise care and diligence required of a trustee in the exercise or discharge of his or her powers and duties. And so I might add that they deny that that is the duty of a trustee. The consequences of Omit's conduct are dealt with from paragraph 41, which says, as a result of the instructions given to Omit by Matco, then under the control of Fidentia people, Omit paid an amount of 1.2 billion rand to Matco, and they thus placed the funds under their control. And the Fidentia wrongdoers do not invest the funds for the benefit of trust beneficiaries, but instead utilized the funds to pay a substantial portion of the purchase price of the shares in Matco, which was owed by Fidentia to the selling shareholders. The various payments were not made for the benefit of the beneficiaries. They did not invest the money for the trust, but rather transferred the money to other companies where the money was used for purchases, which the lady will hear in the curator's report from Mr. Papadakis, how this money was squandered on game farms, on spas, on choir, on Boland rugby team. The lady would hear how on vacant stands on the beach, on the shore. The curators admitted the trust's claim in the amount of 1.1 billion rand. And at the end of the curatorship, the curators then took the assets, sold of whatever they could, but the loss was 850 million rand. So of the 1.1, they recovered about 400 million, but the loss is about 850 million. And then we say that it's Omit's conduct which caused the loss. It is the plaintiff's case that if Omit had complied with its duties, Standard Bank and the Registrar of Collective Schemes would have been informed and become aware of the October 2004 facts. Standard Bank, as trustee of the collective investment scheme, should and would have reported the facts to the registrar. This would have been Standard Bank's duty in terms of Section 70 sub 2 of Cisco, which provides that a trustee or custodian must report to the manager any irregularity, and if steps are not taken to rectify the irregularity, it must as soon as possible report such irregularity to the registrar. So had they told Standard Bank, had Omit told Standard Bank, that's what Standard Bank would have done. They would have gone to the registrar and told the registrar, and the registrar, in terms of his duties, could and would have reported the facts to the Registrar of Financial Services Providers. And he has powers that he would have exercised, and he would have ensured that the funds were not released. The facts would have come to the attention of the Registrar of Financial Services Providers through the reports of Omit and Standard Bank and the Registrar of Collective Schemes. And at 46.6 pursuant thereto, the Registrar of Financial Services Providers could and would have instructed an inspector to carry out an inspection of the affairs of FAM. If the registrar had been made aware of the facts, then the registrar would have declined or cancelled FAM's registration. As a consequence, FAM would not have been able to lawfully deal with the funds. And again, similarly with the Master of the High Court, if the facts were brought to his attention, he could and would have exercised the powers granted in terms of the Trust Property Control Act, which grants the Master powers to cause an investigation to be carried out. So we say any one or more of those actions referred to above would have exposed the manner in which the Fidentia wrongdoers had dealt with the money and would have prevented the loss, in that it would have prevented Fidentia wrongdoers from having dealt with the funds as they did. And thus we say that Omit caused the loss by failing to report these matters as they should have done. Ladies, so far as the defence is concerned, they've raised a special defence of prescription. That we filed a replication to say that the debt did not arise when the defendant says that it arose, but only when the curators got to know of the facts, and we'll show when that was, and that we were well within the period to prevent prescription. But they have the onus there, milady, and so what we will do is we will let them run their case on prescription, and then we will lead evidence in rebuttal. And finally, insofar as the merits are concerned, we prepared, milady, that we had a pre-trial meeting at the time, and I don't know what's happened to this directive, but we had to, I don't know if the directive exists anymore, but when you prepare for trial, you had to do a statement of common cause issues and those in dispute. And that was agreed to in the pre-trial minute. We referred to that let me just see how the minute was, the minute is at 004360. But we prepared a schedule, my lady. That schedule, with the parties prepared a schedule, plaintiffs and defendant. That schedule is at 004-366. I wonder if I may take you to it. It's 004-366. It's a 48-page document. We took just about every allegation in the particulars of claim, and we set out those which were common cause and those which are disputed. And the lady will see that common cause is in blue and what's disputed is in red. We sent this to the defendants, and they had no addition to make, save to state that, of course, if anything in the pleadings is different from what is stated here, then the pleadings will prevail, and that goes without saying. But there were no additions made. And so, my lady, we would have hoped that there are a number of issues which would not be in dispute in this matter, which is going to lengthen the trial, and we will reserve our rights later, if need be, to seek a special costs order, because some of these are formal matters which really should be admitted. I'm not going to take my lady through all of it, but for example, can you go to 367? 367 paragraph 2.1. This is in dispute. That the trust was originally known as the CFM Trust until 19 June, when it changed its name to the Matco Trust, whereafter it changed its name to the Living Hands Umbrella Trust. We will hand in the necessary documents now to prove that that is the case. Page 368, paragraph 3. 3.1. It's in dispute that the Matco and Mine Workers Provident Fund entered into service level agreement on 5 September. Well, it's attached to the documents. We don't know why that is disputed. It's at POC 3. What is common cause is that paragraph 4, 369. It is common cause between the parties that the trust was the recipient of funds received from beneficiary funders, such as the Mine Workers Provident Fund, which paid money to the trust for the benefit of the trust beneficiaries, being the dependents and nominees of deceased members of the beneficiary funders, for whose benefit money was paid to the trust, including children, as contemplated in the trust deed. Page 370, paragraph 5.1. It's in dispute whether Living Hands was a trust administration company at all times relevant to the action. And so, my lady, there are a number of disputes. I can just have a... One of the disputes, my lady, is I referred you to a letter which was written on the 19th of October 2004, accusing Old Mutual of not having a mandate and there being a discrepancy, and we say that that was not responded to. That is disputed. They deny that that was not responded to, but we certainly don't have any discovered documents showing that that was responded to. So, my lady, we will deal with all of these matters, and unfortunately some of it may lengthen the trial, but we will do what we can to get what should be formal admissions out of the way. Finally, my lady, I just want to tell you what the position is regarding documents. And that you'll find at paragraph 52 on page 24. My lady, we said at the pre-trial conference, it was agreed that documents are what they purport to be, without there being any admission of the correctness of the allegations contained therein, and need not be formally approved. Well, that's the usual type of agreement one would expect when agreeing on documents for use in the trial. The minute of that meeting provided that any party may require the other party to formally prove a document which that party intends to rely on. But in terms of the minute, that was to be done by 28 May 2021. And no notice to formally prove documents was received from the defendant by 28 May 2021 or to date. So documents will be handed in, milady, on this basis, by virtue of this agreement, without having to prove them. And finally, milady, I've mentioned that we intend calling approximately 7 witnesses, and insofar as the defence of prescription is concerned, they have the onus, and we'll lead evidence in rebuttal. So that is our case, and I see it's just about the tea break, and if subject to anything the lady may have, we will call our first witness, who Mr. Bester will lead. We'll do that after tea, if we may.
It is important that we adjourn for tea in order to also prevent the screen fatigue. So we will adjourn for tea and reconvene at 11:30.
Thank you, lady. we want to call our first witness, who is Advocate Stamella, and Mr. Bester is going to lead his evidence.
Thank you, Mr. Epstein.
Thank you, milady.
Just give us a moment. Just be assisted with the camera for your witness.
Yes, milady. It seems that the overhead camera is showing instead of the face camera.
Yes. I'm going to give you a few minutes to assist the witness to be well adjusted so that we can see him as he testifies.
Yes, milady. If milady will just allow us a moment to just solve that problem.
All right. So take it as also a warning in future that these technical issues need to be sorted before we start. Otherwise, they do take a bit of time.
Yes, no, we apologize, milady, quite correctly.
Of course.
Thank you.
Hi, Andy.
Caller, please answer your phone. Thank you, milady. As Mr. Epstein has pointed out, Mr. Tola Stimela is the first witness for the plaintiffs.
All right, let me swear the witness. Mr. Stimela, will you spell your name for the record, please?
My lady, it's
Yes.
Xola. Surname is spelled Stemela.
Do you have any objection in taking the prescribed oath?
No, my lady.
Will you swear that the evidence you are about to give is the truth, nothing but the truth? Lift up your right hand and state, "So help me God."
So help me God.
Before you start, Mr. Bester, I think, is the witness familiar with the whole protocol that we had devised for this trial?
Lady, understand so, but I would propose that we, on the record, just go through that aspect with him, not step by step, but just confirming on the record that he has read it and will abide by it.
Well, you confirm the aspects that are relevant for the conduct of the trial with him.
Thank you, my lady. And before I commence, I just want to point out, as a matter of housekeeping, at some point that is appropriate, we will move for an amendment. My lady may see that Mr. Stimela's surname is misspelled on the pleadings. The first E appears as an I, but we'll deal with that when it is appropriate.
Yes.
Thank you, my lady. Mr. Stimela, have you had sight of the witness protocol for this trial?
Yes, my lady, I have.
Do you confirm that you will abide by that protocol?
Yes, I will abide by the protocol that has been provided to me.
The room where you are, do you have any access to anything but this platform and the case lines platform?
It's only this one, but I may well mention that the IT is still here for the purposes of alignment.
Thank you. And do you have access to the case lines platform?
I have, yes.
And are you able to navigate that as I refer you to documents on that in the case lines court file?
Yes, I will.
Thank you very well. Mr. Stimela, please inform a lady what your current occupation is.
My lady, I am a practicing advocate and a member of both the Johannesburg Bar and the Mthatha Bar. But for purposes of my presence and witnessing here, I am in a capacity as a trustee of the Living Hands Umbrella Trust.
So you are the third plaintiff in this matter in that capacity?
Yes, I am the third plaintiff in these proceedings.
Can I ask you to go to the pleadings bundle, that is 001. And there, I would ask you to go to 001-85. You'll see there document letters of authority. Are you familiar with this document?
What number it is?
001-85.
If you may bear with me, I'm just scrolling down.
All right. Now, here it is, Mr. Bester. I thought that your attorneys are aware of how to use case lines to direct a witness to the document. Because if we go like this, it will take forever. So please assign somebody in the background to lead the witness to the documents and all the witnesses to do is to accept.
Thank you, Milady. We have that. It seems that will be an easier setup. Mr. van der Walt will do that.
Right.
He's ready to proceed. Mr.
And I think Mr. Bam is here, so I need to just allow him to address me. Mr. Bam?
My lady, if it may assist on non-contentious issues as my learned friend is taking the witness through now, we would have no difficulty if the witness was led. And in other words, matters such as he's a trustee. If the question is asked, we need not go to the document. So we have no difficulty. I give it to my learned friend's discretion, and I've litigated against my learned friend. He's got a very good discretion, and I say that sincerely. So on non-contentious issues, if he wants to lead the witness, and if I think at any stage at my invitation is crossing the line, I gently state so. But if it moves, if it helps moving quicker, we have no difficulty.
Yes. Thank you, Mr. Bam. So there it is, Mr. Bam.
Yes, thank you, Mr. Lady. Thank you, Mr. Bum, for that assistance. Mrs. Tamela, are you able to see the case lines moving at this stage? You should be seeing 001-85.
Moving.
No, are you on that page?
I am on the page 85.
From your own navigation, or?
Yes, from my own navigation. It's the letters of authority.
Let me just check that our system is working. I'm going to ask Mr. van der Walt to go to 001-60. Mr. Samela, please do not do anything. I want to see whether you can follow his presentation.
So let the court assist you. Mr. Stimela, if you go, you see there's the home button, and then there's a find, and then there's a view button on case lines.
Yes.
Next to that button is a button that says present, right? And below that, it says follow presenter. So click that on so that you can be directed.
Not from my screen, my lady.
Did you click the button, Mr. Stamela?
I'm back on the one with the home.
Next to home, there's find, and then view, and then there's present. Press the present button. It's at the top.
There's home, there's invite, there's view hearing, there's support.
We don't have the present button.
No, not at all, my lady.
Right.
Mr. Stamela, does it show there following Mr. van der Walt in a bar below that? Below the buttons?
No.
Milady, my apologies. I was not aware of this difficulty. Can I ask Milady's indulgence for 2 minutes so that we can just make sure that that setup is corrected?
I think we need to proceed. I think this is something that parties must sort out during lunchtime, just to make sure that whatever platform you are on case lines, that all the witnesses can be directed to the documents, and all they have to do is to click. That is back office. That can be sorted at lunchtime. We have to make do with what we have right now.
Thank you, Milady.
Yes.
Mr. Stamela,
I've got the present button. Yes.
So click follow presenter if you're there now.
Yes. Then it takes me to Mr. Fraser van der Walt.
Very well. Mr. van der Walt will now take you to the correct document, so you don't have to do anything from your side on case lines now. Thank you.
Thanks.
So let's just run through this again. Can we go to 001-60?
I've got the document on screen.
That is a trust deed. Are you familiar with that trust deed?
I am familiar with the trust deed.
Can I ask you then to look at clause 4.1 thereof? You will find that a 001 2021-66.
I've got it on my screen.
Thank you. You'll see the object of the trust.
Yes, in clause 4, object of the trust, yes.
Thank you. And can you just briefly take the relationship through those so that we understand the object of this trust?
The object of the trust, if I may summarize it, is to make payments to the beneficiaries of the trust.
And where do these trust funds come from?
What then happened when I came in as a trustee is as follows. We were handed a database by the curators, but we collected the database from Akani. In the database itself, you will come across beneficiaries. And all the beneficiaries of the trust that we are paying in terms of the trust deed are in that database. There will be a trust, and then below that trust there will be the descendants of the main member.
If you say member, a member of what?
Let me say the deceased, because we've got almost about 380 funds that have made deposits into the Living Hands Umbrella Trust. And out of those, you will find that these will be the beneficiaries. We've got almost about 67,000 beneficiaries. Of those 57,000, it's only about 57 that is active. When I mention active, it means that the remainder is the difference between the 67,000 and the 57,000 are beneficiaries that have been terminated. For instance, their benefit may well be that it has been paid over. They are no longer beneficiaries of the trust.
So do you mean that some have been paid up, all the funds that could have been paid?
Yes.
Thank you. And who would typically be these beneficiaries of the fund members?
Typically, it's the beneficiaries I would say that is, you would mostly find them on the SASSA database. We are talking about individuals here that it still matters to them. What will they be eating? The clothes, and most of them are unemployed.
So what? My apologies, please proceed.
Yes. And now, if maybe I may further differentiate, is that of the 57,000, those that have been identified in terms of gender, there are almost about 33,000. Those that have been identified in terms of gender, male or female. Of those 33,000, the majority of them are women. Then the remainder will be male beneficiaries.
Thank you. And are you able to tell us the funds from whom the funds came? Were there additional payments made into this trust by these funds since you have taken over as trustees?
There's only been one source that we have been getting funds from since taking over in August 2012. And it's the allocations that are coming from the curators. of the fiduciary code. As I understand it, they will go out, try and identify the assets that belong to the fiduciary code, liquidate them. And because we are about one of the creditors, then we will be paid our allocation. Of course, we are the major creditor when it comes to them. So the bulk of the allocation is coming to the Living Hands Act Trust. Other than that, we have never been getting any funds.
Thank you. And the distribution of those funds, how does that happen?
What then we were presented with when I came in was that how do you distribute insufficient funds to beneficiaries whose number still remains as it was? We then sought out the services of the financial experts to give us a formula on how then must we distribute whatever allocation comes to the trust. And it is in terms of that formula which we apply in all funds that are coming to the trust that we will distribute to the beneficiaries.
Thank you. Now, can I ask you to look at bundle 009-2438?
Yes, I can see it's just on my screen. Yes.
Yes, tell us about this document.
It is the court order. It is in terms of that court order that we make payments based on. Because what it does is that we need to apply the funds, and whatever rand amounts is calculated in terms of that formula, we will then pay it to an individual beneficiary.
And why was it necessary to have a formula?
It was necessary in the sense that on the one hand, we had insufficient funds. On the other hand, the number of beneficiaries was remaining the same. So the monies that were coming were not enough to cover for the benefits that ought to have been distributed to the beneficiaries. There was a shortfall. How then do you distribute a shortfall to begin with? Hence, we then employed the services of financial experts that would take into account a number of issues and come out with a formula which will apply on the understanding that that formula, if applied, will then bring about a fair, even distribution to the beneficiary.
In that regard, can I ask you to go to 009-2441, which is an annexure to that court order that you've just referred to?
Yes.
Perhaps you can just explain to your ladyship what this is.
Yes, I can see it. That's the formula that we always apply in order to determine the rand amount of each beneficiary. And it is that rand amount then we will pay it to the beneficiaries. If I may, is that we have had instances when we apply, and we are applying the formula evenly on everyone, where beneficiaries would walk away with 50 rands.
And speaking of the beneficiaries, you've told us that they're mainly women, that they're the beneficiaries of these members, the deceased members. If you say they're women, perhaps you could just explain their relationship to the deceased members. Who are the beneficiaries relative to the deceased members?
What happens is that the guidance of the further, which is another level of the beneficiaries, which is the children. The guidance would mostly be the spouses of the deceased, the uncles, the aunts, the grandparents.
And why would that be?
It's because they are the guidance in the sense that below that level, then you will come across beneficiaries who are minors. And in terms of the benefit, we don't pay to a minor beneficiary, but rather to an adult who would then be the guardian, who is either the mother, the uncle, the aunt, the grandparents.
Thank you. Now, you mentioned that a substantial number of funds contributed over time. Can I ask you to have regard to 001, that's a pleadings bundle, 001-86, that is POC 3.
Yes, the document is on the screen.
You'll see there it's headed Service Level Agreement.
Service Level Agreement.
Yes, between Mercantile Asset Trust Company, Pty Limited, and the Mine Workers Provident Fund. Are you familiar with this document?
That document predates us.
Are you familiar with the document in the sense that you know about it?
No, not at all.
Thank you. Now, can I ask you a few more aspects about the situation of the trust? Up to this time, how many beneficiaries have you, as the trustees that took over funds from the curators, how many beneficiaries have received funds from you?
The current status as it is at the moment, and when I talk about the current status, I'm talking about the status as at 31st of January 2022. We have paid almost about 30,000 beneficiaries.
And are you able
that have been traced and their accounts verified?
Does that mean that the balance of the beneficiaries could not be located, or what is it?
The balance of the beneficiaries we haven't managed to allocate, and for a number of reasons. One of them is that the beneficiaries are not only South Africans. We've got beneficiaries that are coming from the Swaziland, Botswana. So in that manner of speaking, it poses its own challenges insofar as tracing is concerned.
Are you my apologies, please continue.
Then in terms of rand money of these 30,000, we've paid almost 46,000, closer to 47, not 1,000, 46 million rands. That's the rand value that has been paid to the 30,000 beneficiaries. It's about 46 million rand. What we have, and that's the portion that we have not managed to trace and pay, we have invested almost about 32 million rand.
The 32 million, is that the totality of the trust funds currently?
Currently at the moment, and it belongs to those beneficiaries that we have not been able to trace and pay.
Are you able to tell a ladyship approximately how much is paid out on a monthly basis by the trustees?
It varies, but I would say that it's almost about 100,000, 150,000 that's paid monthly to the beneficiaries.
Now, these payments, on what basis are they made? What I want to understand is you refer to people who get paid up at some point and others who have not received all their money. But do you make regular payments to beneficiaries, or do you make a single payment to them when you have found them? Perhaps you could just explain that to a ladyship.
What is happening currently is, and each and every week, to those that we have managed to trace and find and verify their banking details, we would then pay weekly. But what it then means is that in a month, we would have made about 4 payments, which makes it a monthly payment. And this 100,000, 150,000 I am talking about, it's that monthly payment, which is a combination of those weekly payments that we're making.
Thank you. You mentioned that there are also beneficiaries in neighboring countries. Why is that?
It's the composition of the beneficiaries. It's that you'll find them around the SADC. Not only are they, because one of them you must understand is that most of the beneficiaries that we have belong to the Mine Workers Provident Fund. So in some way they are connected or related activities that we have. And if we look at the mining itself, it was drawing employment around SADC, not necessarily in South Africa. Hence, we've got that spread or picture, which is reflected in the beneficiaries.
Thank you. Can I then ask you to turn to bundle 17 and turn to 017-27? This is a bundle of documents pertaining to certain entities, including the trust. Page 27.
I'm still waiting for it to come out.
Yes, Mr. President. Just whilst you're waiting for your document, can you just clarify with the witness the 46 million rand, I understand it, that's been paid out. It's over what period? If you could just clarify this for me.
My lady, the 46 million rand, it's over the period since I became the trustee of the trust. And I became the trustee of the trust round about in August 2011. So that's the total amount that has been paid since then up to now, which totals about 46 million rand.
Thank you, Mr. Basic.
Thank you, Milady. Do you now, Mr. Samela, do you now see page 017-27?
No, it's still freezing on the particulars, which is 1-8.
Let's just see if we can refresh that. Perhaps Mr. Van der Walt can go to another page and go back there to just see if that will unfreeze. Perhaps just go back. Sometimes you'll get kicked out, Mr. Stamela, from the presenter function. Go back and just click again, follow presenter. Do you have that, Mr. Simona?
It's still reflecting a blue screen.
Does it reflect that you are following Mr. Van der Walt?
Yes, I've just clicked on Mr. Van der Walt as before.
And on which page?
Yes. Then there's letters of authority that is slowly reflecting itself.
Thank you. So then it seems that you are now in the right place. Now at 017-27, up to, and I'm now making use of Mr. Bum's proposal, so I'm going to attempt to short circuit this. From -27 to -36 appears a series of letters of authority.
Yes.
Those documents, where are they from? So where were they obtained?
They will be obtained from the Master's Office in recognition of our position as trustees. And whoever is authorized will be a trustee. So they will be coming from the Master's Office. And
do you have custody of copies of these documents or not?
we've got custody because we were presented with the database, and some of the documents were coming from the Master's Office itself.
Thank you. Can I ask you to go back to POC 3, which is in the pleadings bundle at 001-86. You mentioned, do you see the document?
It's
the service
yes,
level.
H86 service level agreement.
You mentioned that this document predates your involvement. Is this a document that the trustees have in their possession? Of course, it's a copy.
I can't recall because there are a number of documentations that were presented with. It may well be that it's amongst the documents that were coming in from the curators and from the Master's Office.
Thank you. Now you will just give me a moment. Thank you, my lady. Nothing further from Mr. Stamela.
Thank you. Mr. Bum?
Thank you, my lady. My lady, we have no questions in cross-examination.
Thank you, Mr. Bum. Just for me to... Mr. Stamela?
Yes, my lady.
I just need to clarify from you so that I get the sense of the numbers of the beneficiaries that are involved.
Yes, my lady.
So, you made reference to close to about 67,000?
Yes, my lady.
Beneficiaries?
Yes, my lady.
Beneficiaries, all in?
Yes. My lady, what is happening is that when we received the database, there were about 67,000 beneficiaries.
Yes.
Yes. What then we have determined, and which we call them active beneficiaries, it's about 57. Of the 67,000, there are about 57,000 active beneficiaries. And the difference between the two, it's because of termination.
Right. Thank you for clarifying that. And you also testified of that 57,000, about 33,000 are women, you said. That's what I understood.
Of the 57,000, my lady, we've got about 33,000 whose gender is identified in the database. They will either be identified as males or females. And within that 33,000, we've managed that is to declassify it in terms of how many are males and how many are females. And in terms of percentages, yes, then you'll find that of the 33,000, 50%, the majority of them are males, have been identified as females, as females. And then the remainder will then be males.
Do you know how many of that constitutes children?
My lady,
obviously, they are not. I assume you're now talking about the guardians who are the recipients, but I just need to have a sense of how many children are on beneficiaries from the payments that are being made. Would you have an indication of that?
I wouldn't have concrete numbers and percentages, but how then I would respond is that because a number of beneficiaries are minors, or were minors then, you will come across a main member who has got 2 children from wife 1, 3 children from wife 2. And out of that, I would assume that it's the bigger number of the beneficiaries were minors then, even though by now some have attained the age of majority.
But you don't have a sense of what...
I don't have that as a concrete number or percentage.
That's all I wanted to establish in terms of the numbers of minor beneficiaries that are involved. Right. And you also testified that you retain about 32 million of funds for untraced beneficiaries and that you've invested in.
Yes, my lady.
Do you have a sense of how much you've received from curators all in from the period you started as trustee? Can you give me an indication?
My lady, there has been 2 payments that came in since I became a trustee from the curators. The first payment was around 2030. Then it was followed by another payment around 2017, somewhere in 2017.
The numbers?
The numbers, if I look at the numbers, we've almost about 100 million, the combination of the 2 payments. Because what then happens is that the second payment is almost half of the first payment.
Thank you. That clarifies my better understanding of the evidence. Are there any questions arising from my questions?
Nothing. Thank you, my lady.
Nothing from me. Thank you, my lady.
Thank you.
Thank you, my lady. I'll hand back to Mr. Epstein.
Mr. Epstein.
Thank you, my lady.
I cannot see you and I cannot hear you. And yes, thank you for muting. Mr. Epstein? Mr. Epstein?
Are you able to hear me, lady?
I can hear you, but
I don't know why this video is not coming on. And can you hear and see me?
I can hear and see you now.
Milady, fortunately or unfortunately, we've gone much faster than we had anticipated. I would have, our next witness is Mr. Papadakis. I would have tried, because of the point we've reached now where we could have called another witness, I would have tried to call another witness this afternoon. But unfortunately, somebody who is in the vicinity and who was due to consult with us on Friday took ill and she couldn't come and see us. So I'm going to have to ask for an indulgence, and I hope Mr. Bam will not object that we stand down till tomorrow morning so that we can start with the evidence of Mr. Papadakis.
All right. Let me first release Mr. Stimela. Thank you for your testimony. You are excused. Mr. Bam?
Thank you, my lady. My lady, we certainly don't object. Whilst we're at it, though, and having heard Mr. Stimela's evidence, you've seen I've had no questions. Can I again repeat that to the extent that there's evidence that post-dates the relevant period, in other words, the time when Omut made transfer of the funds, to the extent that my learned friend wants to speed that up, they can lead the witnesses. It can go a lot quicker than it went this morning, because we're not going to take issue of it. I've gone through what was given to us as a witness statement by Mr. Papadakis. I can tell you, my lady, at worst, if that's the testimony, there's going to be 3 or 4 questions. It's not going to be a matter of any moment. So if that's, and I'm not going to dictate to my learned friend how to run this trial, I'll never do so. But to the extent that evidence falls within that category, we're not going to take issue with what's the obvious. Thank you.
Let me just ask you, Mr. Bam, don't go away. I obviously appreciate giving the other side some line of sight. What I was curious about, though, is that when Mr. Epstein gave us an opening address, he seemed to indicate that you also placed a number of issues which, on the face of it, I don't know what your case is going to be, ought to have been admitted further. Is it perhaps not an opportune time to also visit that?
We'll look at it. But can I just say this, my lady, so that your ladyship understands where we're coming from?
Yeah.
I'll invite you. My own friend took your ladyship through the particulars of claim, and invite your ladyship to have regard to it.
I have.
Yeah. And you'll see that the factual case against Omut is within a very narrow ambit. In other words, it was those couple of days leading up. First of all, it was the background relating to what happened in Fidentia. That is outside of our control. I'll leave my own friend, Mr. Epstein, to deal with it. It then goes to those exchanges which led to the payment out to FEM, and what FEM did with it. You'll have seen from Mr. Papadakis' witness statement that the theft thereafter occurred because it leaked out of FEM. Now, when we deal with the issues and when we've addressed our mind to the issues, it has really been about what's the case against us? What's the case that we've got to meet? And the case against us is, in essence, in the circumstances in which you made payment of this amount out to a new asset manager within the Fidentia group, you ought not to have done so. Instead, you ought to have gone to Standard Bank and whatever the case. Now, substantially, we think that on what is before you, which includes the correspondence, that will substantially turn into a matter of legal argument. We may or may not call a witness, but we'll see how the evidence goes. And what I'm trying to point to is that, and I see from the list of witnesses that some of them were trustees or directors within the Fidentia group at that point in time. They of course, we'd wait to hear what the evidence is, because there may or may not be matters which are material. But to the extent that you're talking about matters that the new directors or trustees or the curators had dealt with in the curatorship in order to recover funds in order to ascertain who had stolen those funds. Well, that's not really an issue, my lady.
I mean, I appreciate that, but I think for good order and good housekeeping, perhaps you might want to revisit that so that.
But I just want to make it clear because you know, at the end of the day, it's easy to point a finger at the defendant. We've also got to be mindful of the case we've got to meet and what the case is against the defendant, what the issue in the case.
I understand, and I hope you do not impute that the court is already pointing fingers. It will do that in due course. But all I'm saying is that given you will open, obviously, when you are about to lead your evidence, but given that we've got downtime, and given the areas that Mr. Epstein has already taken me through, and some of them seemingly are areas which ought not to be in dispute.
Okay.
I really are inviting you to revisit your position, just like as you've done it this morning for me, to when the time comes, tell us whether you are disputing those areas or not.
I'll invite Mr. Epstein, and we'll attend to it today, to send us a note of the particular paragraphs in the list of issues that he wants us to reconsider, and we'll do it today.
Yes, I thank you.
Thank you.
Yes, Mr. Epstein.
The lady, no, we take note, of course, of what Mr. Bam has said. And we understand that with litigation, especially a matter of this nature, that when pleadings are filed, there are certain matters which, as a matter of course, are put in dispute. And one would hope that by the time you get to trial with the exchange of particulars and pre-trials, that a lot of issues which were originally disputed would no longer be disputed. I don't want to pretend to give the other side homework, but we've got the document at 004366. We've set out clearly what is in this common cause, what's in dispute, and if they can go through that document again, go to those matters which are highlighted in red and tell us what is in dispute. Because whilst I appreciate what Mr. Bam is saying and the offer he has made, we can't leave any stone unturned. We have to be sure that we cover all the allegations which are disputed and not leave any out and find ourselves at the end with something that we should have proved that we didn't.
My lady, can I just say this? My learned friend knows what evidence is going to lead. It's a very simple task. If my learned friend just sends us a short note on the paragraphs he specifically wants us to lead, which may avert unnecessary evidence, we'll attend to it today.
We'll do that. We'll do whatever we can to help.
Surely that's the invitation.
Thank you.
All right.
Thank you. I'm grateful. Thank you, Hilton. We'll hear from you. Thanks a lot.
Yes.
And may I just ask through you, my lady, Hilton, and I'm sorry, I'm talking with a sense of familiarity. I can't do that with my own friend. Hilton, when it's emailed to my attorney, will you just copy us in on it as well? Thank you. Thank you, my lady.
Yes. Thank you. So we will adjourn till 10 o'clock tomorrow morning with the direction that parties will liaise to narrow further any areas in dispute and to discuss that amongst them.
Thank you.
Court is adjourned until 10 tomorrow.
Thank you.